Good afternoon. Welcome all of you at the second session of our international seminar of mediation, the role of mediation in resolving legal disputes. I'm really happy again to say that we are here together. It's my pleasure and honor to be able to be a coordinator as such a large undertaking and such a large international seminar. I would also like to add, because not all of you were participating from the beginning, that this seminar, in this seminar, more than 150 people from all over the world have declared to participate in. So it's a huge. We are very happy because of this, and the organization wouldn't exist without Professor Kinga Flaga-Gieroszyńska, who is not with us now because she has some other obligations because of being vice rector, and also many thanks to Dr. Joanna Misiukaitis, head of the International Affairs Department, because these two women are the ones who give energy to the international area and to make a lot of international things. Unfortunately, we don't have this first speaker because Dr. George Khatidze, sorry for my pronunciation, but your names are very exotic for me, from Georgia, is not able to participate in conference. But before this second session, we had one question dedicated to Dr. Bianca Di Carlo. So Bianca, if you will be so kind and answer the question about the mandatory mediation in Italy, it will be very nice.
Of course, thank you. Can you hear me?
Yes, we can hear you.
Okay. So thank you for the question, first of all. So as I said during my presentation, compulsory mediation has significantly influenced the spread of mediation in Italy. So the statistic demonstrates that the vast majority of mediation is still mandatory in Italy. Of course, in an ideal world, there would be no need to make it compulsory, to make mediation compulsory. Unfortunately, we live in a world where mediation is still unknown to most citizens. Of course, it's important to foster public support for mediation, to underscore the role of mediators, to encouraging individuals to choose this method, this alternative method, but it's not enough in this moment. So we still need, in Italy, we still need a law requiring parties to know about mediation. Attempts to spread it through other ways are not yet strong enough. So therefore, although I personally believe that the true spirit of mediation consists in voluntariness, a key reason for introducing compulsory mediation is the possibility the possibility of being known by as many people as possible. So this is a tool to try to change the culture of mediation through the law, showing to citizens that it's a serious instrument. So in this way, lawyers and citizens are obliged to inform themselves and learn about mediation. But one thing, in any case, the choice to continue after the first meeting remains with the parties. So it's a mandatory mediation and not a mandatory agreement. And this difference is really important to remember. So yes, this is my answer, and I'm not sure if it's complete for you, but that's the reason why I think that mandatory mediation is still necessary.
Thank you so much. I'm not sure if there are any other questions for the first sessions for speakers who are having their speeches in first session. I think that this is very important what you said, because as a legal advisor, I can see that this court hearings and court cases are very long. So I think also that the mediation is the view of future to get more effective and more faster solution that people want to get. If there's no other questions, of course, after this session, we also will have time for discussion. And you can also...
Thank you so much.
Thank you so much, Bianca. And you can also add your questions via chat. So this is possible for all the time our speakers have their presentations. So the first, as you can see, the presentation of Bernadette Uvicieza, sorry for this wrong, completely badly pronunciation. She's an accredited mediator from Center for Effective Dispute Resolution and also court accredited mediator under the Rwanda Court. So our co-organization is very important co-organizer of this seminar, Next Mediation. She's also a member of the Ombudsman Global Mediation Panel and member of the Weinstein International Foundation, and a network of more than 100 of mediation promotes worldwide. And during this seminar, Bernadette will give the speech entitled The Promise of Mediation in Rwanda, Building on Our Culture and Homegrown Solutions. Before I will give you the floor, I will just tell some organizing issues. All of speakers have access to a microphone and camera, and you have this access. Also, I ask you to keep an eye on the time. Each speech lasts 20 minutes. 5 minutes before the time is up, I will turn on my camera, which will be signal for you that there are 5 minutes left in the speech. So now, Bernadette, the floor is yours, and please start your speech.
Thank you, Alexandra. I'm wondering if you can see the presentation.
Yes, we can see your presentation and we can hear you very well.
Okay, so thank you very much. I would like first to thank you for organizing this knowledge and the practice forum platform, and we learned a lot about mediation models around the world, and for us, it's really time to learn from you what is going on around the world. I would like also to recognize the presence of many of my colleagues mediators from Rwanda. My talk today is on the promise of mediation in Rwanda, building on our culture and homegrown solutions. Sorry. So, mediation is not a new practice in Rwanda. Mediation was at the heart of the Rwandan justice system before the colonial rule. The justice system was structured to offer a variety of dispute resolution forums to allow Rwandans to choose a dispute resolution forum that meet their needs and the nature of the dispute. But at each level, mediation principles were at the heart of the process: participation of conflicted parties in this process, opportunity for expression and understanding for everyone present, and community participation. It's okay, you are still hearing me?
Yes, we can see the presentation and we can see the slides are moving on, so everything is perfect.
Okay, thank you. So the community role was what William Ury, professor at Harvard University, names the third side role. According to Ury, the third side is the surrounding community, which serves as a container for any escalating violence. The third siders strive for a resolution that met the legitimate needs of the conflicting parties, at the same time met the needs of the wider community, a triple win. The goal in resolving dispute was to establish the truth of what happened, to repair the harm or damage suffered, to restore community cohesion, and ultimately preserve the integrity of the nation as a community of destiny. This justice system sustained the governance of the nation until its interruption by the colonial administration that imposed the adversarial court system based on another philosophy, and this in 20th century. After the genocide against Tutsi in 1994, the regular courts were evidentially unable to try the huge number of genocide cases. White justice was a necessity for Rwandans to heal and to continue to live together in their community, their villages. The new leadership looked back to the pre-colonial justice system and building on the key principles of the Rwandan legal system, established a legal system based on the rule of law, but also on a dialogue and the search for consensus in resolving problem, of course, dispute and conflict. Mediation principles at the foundation of the Rwandan legal system before the colonial rule were embedded in the first constitution of Rwanda after the genocide against Tutsi in 1994. In its preamble, the constitution promulgated in 2003 reaffirms the commitment of Rwandans to build a state based on the rule of law and the resolution of problems through dialogue. In addition, Gacaca courts and the local mediation committees called Abunzi were established alongside the conventional court system. Gacaca court for handling some categories of related genocide crimes, and local mediation committees for major disputes impacting peace and harmony between citizens. The Gacaca court for genocide crimes were established in the constitution and organized by legislation enacted in 2004 as the only way forward in the circumstances where a large part of the population was involved in the genocide. By the end of 1998-9, 5 years after the genocide, fewer cases, less than 400 cases, had been tried in regular courts. It would have been taken many years and many victims would have died before they had their day in court. Almost 2 million genocide-related cases were handled in 8 years by Gacaca courts. Gacaca courts were also designed to provide opportunity for victims and the perpetrators to have a face-to-face dialogue with the participation of the whole community, and opportunity for those willing to confess, to show remorse, but also for victims, opportunity to gather information on what happened, particularly for survivors to know where are the remainings of their family members' bodies, to honor them through decent funerals and to heal. This scheme continued to inspire many initiatives in restorative justice, which is also a form of mediation in criminal matters. In parallel to Gacaca courts, a legislation of 2004 operationalized the local mediation committees Abunzi. This scheme continued to operate for dispute of a value not exceeding an equivalent of $3,000. The Abunzi local mediation committee are elected by citizens in their villages based on their perceived integrity and impartiality. They assist the fellow citizen in trying to settle their disputes, and when there is no settlement reached, they deliberate and take a decision that can be appealed to the court. It is a hybrid process. The RAS report of 2020-2021 shows that 80% of cases are settled at this level of Abunzi. It is a scheme that is appreciated by citizens because it gives voice and empowers citizens in resolving disputes. Beyond the two major initiatives of Gacaca courts and Abunzi local mediation committees as mediative processes based on mediation principles, a research conducted in 2019 to inform the ADR policy recently adopted by the government revealed that after the genocide against Tutsi in 1994, there has been a flourishing mediation practice that includes public initiatives, but also initiatives at the community level, in the civil society and private sector. Among other initiatives, the judiciary, Among other initiatives, the judiciary of Rwanda has undertaken to enhance the use of mediation in litigated cases. First, in 2012, amendment of the Civil Procedure Code that established mediation at the pretrial phase by court registrars, and later by an amendment of 2018 that introduced mediation at all levels of court proceedings. Mediation was introduced for litigated cases in all commercial, administrative, civil, commercial, administrative, and labor matters at all levels of court proceeding. It is a voluntary process led by judicial officers. Judges and registrars have the obligation to encourage litigants to try mediation before trial, but cannot direct parties to go to mediation. The cases can be mediated by judicial officers, judges, and registrars, or by private mediators registered on the panel of court-accredited mediators. Those people you see on the screen are court-accredited mediators. This voluntary system with judges mediating was purposely designed to slowly create among litigants, the legal profession, and the public a new culture of negotiated outcomes, but also a new education about conflict resolution. Like in many other countries, legal professionals have been educated to operate in the adversarial system with its limitations. The voluntary system was purposely designed to take into consideration the necessary transitional period for legal professionals, lawyers, and judicial officials to get a new understanding and appreciation of mediation through knowledge and practice, and ultimately educate litigants about mediation. The Judiciary of Rwanda has undertaken a long-term mediation capacity building program for judges, registrars, and senior officials in the whole justice sector, with the ultimate goal to set the foundation for change within the adversarial court system. Judicial officers are trained to become dispute managers in addition to the primarily function of adjudicators. This mediation training program is open to other sectors and professions: lawyers, in-house counsel in corporate, senior staff in public administration as a dispute managers, member of other professional bodies such as engineers, tax advisors, or accountants. The Chief Justice has established a court mediation advisory committee comprised of all stakeholders to oversee the implementation of the court mediation program, including training and accreditation for court mediators. The plan is to prepare for a court-ordered mediation system in which judges and the registrars will no longer mediate cases, but refer cases to private mediators. We have indeed observed that litigants prefer to be mediated by judges or registrars, while judges and the registrars have continued their primary function of adjudicating cases. Judges and the registrars encourage litigants to choose a private mediator on the list of court-accredited mediators, but some litigants resist because they have to pay a certain amount to private mediators. There are also some lawyers who resist mediation, sometimes because they don't know how to support the client in mediation. Many lawyers are now taking training in mediation, and we encourage them to train also in mediation advocacy. Those are the limitations of a voluntary system, but this voluntary system was a necessary step for us to prepare the public and to create local capacity in mediation. Judges and registrars have had the opportunity to learn about mediation and are prepared to support litigants in creating the willingness to participate in mediation in a mandatory system, instead of parties going into mediation only for the purpose of compliance with the obligation to attend mediation. The Court Annex mediation program is now supported by the national ADL policy adopted by the government of Rwanda last year. sorry. The alternative dispute resolution ADR policy adopted in 2022 is a roadmap for Rwanda to continuously improve, coordinate, and expand the use of ADR mediation to all dimensions of life in Rwanda. Mediation is a key component of the ADR policy, both court mediation and out-of-court mediation. The ADR policy recommended mandatory pre-filing mediation, building on a well-functioning community mediation system and a well-functioning private practice system. In terms of implementation of this policy, it is suggested to start by a pre-filing mediation system in a pre-filing mandatory mediation system in some categories of cases and a court-ordered mediation system for others. There are a lot of awareness activities going on this first year of the implementation of the ADR policy, and the Ministry of Justice is preparing for an amendment of the Civil Procedure Code to introduce court-ordered mediation and a general legislative audit to align the existing laws with the policy. Further dialogue is undertaken with relevant stakeholders in each field of law to agree on an appropriate mediation scheme in family law, in handling dispute complaints, citizen complaints, in administrative justice. Mediation providers in civil society are also mobilized to create a well-functioning community mediation well integrated with the court system for enforcement of mediation outcome. We believe that mediation has promising future in Rwanda. The national ADR policy has provided guidance and direction to all stakeholders. The court mediation program implemented since 2018 has provided opportunity for all legal professionals to shift from a litigation mindset to a culture of negotiated outcomes. And we believe that in the near future, mediation will no longer be an alternative to litigation, but the primary way of resolving conflict and disputes in Rwanda. Thank you all for your kind attention. And if any question, please don't hesitate to ask. Thank you.
Thank you so much. I even haven't had a chance to put on my camera and to show you that 5 minutes left. Thank you so much. This is very, very interesting, especially for us, because this sounds sometimes a little bit exotic for being from other country. But I think that the main goal of the mediation is the same all over the world. Hopefully Professor Edilson Vitorelli is with us, because in the morning I had the information that it was possibility to change the program, and Professor hopefully is with us. So now I would like to ask Professor Edilson Vitorelli from Brazil. Professor is law school professor at the Federal University of Minas Gerais and a federal circuit judge at the Court of Appeals for the 6th Circuit in Brazil. Bernadette, if I can ask you about stop sharing your presentation. Thank you so much. So Professor today will give this speech entitled the Brumadinho Settlement, a case study on mediation regarding disasters. Professor, you have 20 minutes. After 15 minutes, I will put on my camera and show you that 5 minutes left. Please take the floor.
Thank you so much, Alexandra. Can you hear me properly?
Yes, I can hear you.
Okay.
I see you, so everything is perfect.
So thank you. I'm still at the airport, so if you hear something funny, don't worry. But I have arrived at my destination, so I am free to talk to you. Thank you so much for being so understanding with my difficulties regarding this flight today, and thank you all for being here this morning. I will not waste anyone's time. I will share my presentation here so as we can start. I'm going to talk. Okay, thank you. I'm going to talk about you to talk to you today about a disaster that happened in Brazil, and that was mediated in what I've been calling a multi-layer settlement. So let me just give you a brief introduction of what we are talking about here, and then I can walk you through the differences you will see, I hope. This is a very peculiar way of mediating conflicts, and this is a feature of the collective litigation system that we have in place in Brazil. So I will talk essentially in three parts. First of all, I will present to you an overview of the collective litigation panorama in Brazil. Then I will talk about the disaster specifically, and then about the settlements that ended an immense litigation that was going on in this last few years. So this is just something of a little bit of context about me. I am today a federal judge, but until last year, I was a federal prosecutor, and I was involved in the litigation I'm going to talk to you about. So you have to be aware of this. I'm not completely impartial to evaluate what I'm talking about here. I'm presenting also these two books. One of them, as you can see, is in English. So if you want to learn a little bit more about the Brazilian legal system, I published this book, A Supreme Court Made in Brazil, that is available on Amazon. You can find it with this QR code. And the book on the right, which is only available in Portuguese, is the one with which I won the Mauro Capelletti Book Prize in 2019. We actually will have the World Procedural Congress of the International Association of Procedural Law this year again in Lima. So there will be another Capelletti Book Prize awarded there. And I would like to invite you. I will be a general reporter on one of the themes, and I would like to get this to have this opportunity to invite you all, if you have not been to South America or to Peru. I think it would be very interesting. The World Congress is a remarkable opportunity to study what's going on in the legal procedural systems these days. So you know probably that we have two most known models of collective redress in the world. We have the American class actions and the European regulation model. The American class actions is a litigation private attorney model that provides incentives for attorneys to finance litigation and then to receive some money as for fees at the end of the litigation if they are successful. On the other hand, the European model is much more centered in administrative law, in public agencies, and in activities that are centered more specifically in regulation, in thinking about solving collective conflicts through regulation and not through litigation. What's the Brazilian model? The Brazilian model is a kind of intermediate between these two American and European models. We have litigation to address collective conflicts, but this litigation is not dealt with by private attorney, but by public entities, mainly the Public Prosecution Office. I was a member of the Public Prosecution Office till last year, and then they can litigate the cases on behalf of the community, on behalf of the group, but they don't have a personal stake at the lawsuit because they are not going to win anything if the lawsuit is successful. So this specific feature is what put these institutions in a very peculiar situation, because they are at the same time a litigator, but they also are a kind of mediator between the community and the entity or the company, in our case, the company that caused the harm. So this is very, very peculiar and very, very specific. As we have an entity that is litigating but does not have a personal stake in the litigation, it's very usual that these public defenders and these prosecutors assume a kind of mediating role between the community and the entity that caused the harm. And this is what I'm going to show you in the case study. We actually have a lot of class actions. So when you look at this model, you might imagine that the prosecution office is not going to waste its time with collective litigation. They are probably going to do criminal law. And this is a theoretically valid concern, but pragmatically, we have, yes, lots of class actions filed by the prosecution office, and also lots of collective settlements that are mediated by the prosecution office. So these are the numbers from 2019 and 2021. As you can see, we have lots of class actions and lots of collective settlements. So the system works. I don't have time here to go into the details, but trust me when I say that the system works. So what was the Brumadinho case? This is the Brumadinho case. This is a flash of the image of what happened. As you can see, it is actually a mountain of mining waste that collapsed and killed 272 people and caused a tremendous environmental disaster in the area of the state which I live, which I am right now, that is Minas Gerais. So this is the instant that the dam burst. This mining waste flowed to the lower areas at a speed of about 100 kilometers per hour. So that was not much that people could do. They were dragged by this wave of mud, and 272 people, including 2 unborn babies, were killed. This happened in 2019. And so what to do? Now we have to find what we can do procedurally to redress this tremendous disaster. I proposed in my book that won the Cappelletti Book Prize that these disasters are one example of what I call irradiated disputes, which are disputes that have many layers of harms. As you can see, you have deaths, catastrophic property loss, significant property losses, and minor property losses, and so on. So this is kind of way of thinking about these disputes in which you don't have just one group or one kind of harm that is caused to the victims. So this idea that I advanced academically, we try to implement in this case. And so we try to get the idea that if we have different layers of harm, we should have different layers of settlements to deal with the most significant harms that were caused by the disaster. So we had 3 layers of settlements. So the settlement 1, I'm going to call them settlements 1, 2, and 3. The one dealt with catastrophic and fatal harms. 2 and 3 with more less significant, comparatively, of course, harms that came from the disaster. Settlement 1 was signed in 6 months, and it was signed by the Labor Prosecution Office because most of the victims were workers of the company that caused the disaster. So they secured with this settlement a very significant compensation for the victims in an opt-in model. So it was a standardized compensation, and people could, of course, their next of kins could opt in the settlement or could litigate. And this was judging by Brazilian parameters. We're not the US. We don't have multi-million damages, so forget this. But judging by Brazilian parameters, this was a very good compensation. And most of the next of kins of the fatal victims actually opted in this first settlement that was mediated and then signed by the Labor Prosecution Office in only 6 months, which is fantastic when, again, you consider the Brazilian litigation time frame. Settlement 2 were signed by the Public Defender's Office, and it's also an opt-in settlement, and it dealt with compensation for people who had very high property damages, the ones over which the mud flowed shattered. So this was what was called between us the hot zone. So it was the losses that were really catastrophic, and people did not get killed, but they lost everything they had. This settlement was reached within a year from the disaster, and it was also focused on standardized compensation and opt-in. And this had a mediation ingredient, an additional mediation ingredient, which was people could present their claims to a mediator and then change the standard of compensation in which they were. So this was not a fixed standard because people had different houses and different properties. The standard was more flexible, and then people could present their claims in front of a mediator, to the company, in front of a mediator, and then try to change the standard of compensation. These mediators were provided by the court, so we have court-annexed mediation services that were used in this case. But these are not very complex mediation activities, because they are dealing with a standardized scheme and with property losses. The real challenge and the real interesting development we had in this case was settlement number 3, which we call global settlement. This is the one I was a part of, and it took 2 years to negotiate. And this was mediated by a very unusual mediator, which was a judge of the Court of Appeals of the state of Minas Gerais, assumed the role of mediator to mediate this institutional coalition that you can see in the second box. This institutional coalition, which had the Federal Prosecution Office, the State Prosecution Office, the Public Defender's Office, and the State Attorney's Office, together mediated by a state court judge to talk to the company and to find a settlement that was going to ensure the restoration of every repairable environmental losses, compensation for every irreparable environmental losses, and also compensation of collective economic losses. As you can see in this settlement, we don't have individuals, so no compensation for individuals specifically, just compensation for families, for poor families, and for the collectivity as a whole. So as you can see in this case, we had this global settlement was able to build a scheme of reparation that is going to last for many years from now. It's now in its second year of implementation. We had the value of this settlement 3 is about $10 billion, so 10 billion with a B dollars, which makes it the 4th largest settlement worldwide. And Now it's going to be implemented by the same institutions that signed the agreement. So this here is a very interesting experience to study, and of course I have very little time now, so I just want to give you hints of what we have here, because we have public institutions that do not have a personal stake in the litigation, so they can act in a kind of impartial solution between the community and the company. And we also have a state court judge that is acting as a mediator, but he's not a traditional mediator, because he also has authority to rule, and to he did rule in very specific questions, but he had the authority to rule and to subpoena people to be at the mediation session. So this was really, really interesting and really different from what I believe you that are mediation experts see in your everyday experiences. And then what I can say in conclusion is that maybe we can work class actions and collective redress, as you prefer in Europe, as a in different frames, in different profiles of cases. And maybe if we have a better understanding of the characteristics of the dispute, we can calibrate better our tools, including mediation, because I think the way that the mediator operates and the way it conducts her work in a complex settlement should be very different from what we do in an everyday case. So Alexandra has already appeared here in my screen. I would like to thank you very, very much for this opportunity. I hope we can meet soon. This is my contact information if you want to know more. I've written about this case in English, so I can send you the paper, and afterwards you can share it with our colleagues here. Thank you very much.
Thank you very much, Professor. For sure, I will ask all speakers to send me presentations and your materials to share with other participants, because we had some requests about this. Hope to see you. Brazil is so far from Poland, but maybe during International Congress of Procedural Law, we will have the opportunity to meet in Peru. I'm not sure if you are going to be there, but if yes, for sure
yes,
we will
meet
meet there. Okay, so we will meet there. So I'm very, very happy. Thank you for being with us. I know that you are in a hurry, that you are at the airport, so this is especially worth for me that you had this speech. The next speaker is, sorry, if anyone has questions for Professor, because for sure he will be not able to participate in the discussion because he will be in the plane. So if anyone has questions to Professor Vitorelli, please ask the question now. And also, I know that Marta Kuko is ready to speak, but also we had some question before to Bianca again. So Bianca, please answer the question, and we will wait a little bit for maybe some questions for Professor Vitorelli.
Okay, thank you. I'll be brief. So the best way to involve lawyers, in my opinion, the best way to involve lawyers in mediation is to valorize their presence and usefulness during the mediation process. And a good mediator succeeds in making lawyers feel a fundamental part of the mediation. The contribution of the lawyers to mediation depends on their level of preparation in this field, of course, and the difference between a mediation conducted with a lawyer's experience in mediation is clear compared to those conducted with lawyers unfamiliar with this instrument. Usually, lawyers who manage mediation in the best way have themselves been trained as mediators, so they are mediators. And for this reason, of course, they have a very good preparation skills. So this is the answer to the question.
Thank you so much. I completely agree that lawyers as mediators are more effective. Okay, so I don't see any questions for Professor Vitorelli. So thank you again for your speech.
Thank you so much. I will try to listen to you at my phone if I can. So, but thank you very much for inviting me and for your kindness with all this trouble. Thank you.
Perfect. Thank you so much. Thank you so much. The next speaker is Dr. Marta Kukło from University of Białystok from Poland. She teaches civil law, European law, and ADR methods also, and she was a director of the legal clinic at the Faculty of Law at the University of Białystok for many, many years. And for me personally, she's a big mentor of clinical legal education, and I'm learning a lot from Marta. Professor Kukło is the recipient of a Senior Fulbright Award in residence at Columbus School of Law, as well as the Kościuszko Foundation and Pili Scholarship in residence at Columbia University School of Law to conduct research in USA. Of course, Professor Dr. Marta Kukło is also mediator, and she has great professional skills with this. So Marta will today present presentation according to practical remarks on the specificity of mediation in civil disputes involving public finance sector entities. So Marta, the floor is yours. After 15 minutes, I will show you myself on the screen. It means that 5 minutes left.
Okay, thank you very much. Thank you. First of all, I would like to thank Ola, who is a great friend of mine, and all the organizers for such a nice invitation. Thank you very much for giving me a chance to introduce the research that I conduct right now. And yes, as Ola mentioned, I'm going to talk today about those I'm going to give some practical remarks on specificity of mediation in civil disputes, which involve public finance sector entities. And I'm going to talk today more as a mediator than a teacher, because I would like, as I said, I would like to share that experience. But before I start the main part of the speech, I would like to do a short explanation how mediation works in Poland. And I'm pretty sure you are familiar, because the systems, as far as I heard, the systems are quite similar in that context. So of course, in Poland, we have that court annexed mediation. We also have private mediation. We mediate cases in civil law matters. We mediate cases in the other branches of both private and public law. So we can use the mediation procedure in the context of criminal law. We can use it in administrative law. We can also use it in labor law, in commercial law dispute, or all of those family law disputes, as well as some neighborhood disputes or disputes with people who are under 18 years old. So taking into consideration all of that, I'm not going to explain you how the whole system of mediation looks like in Poland. I have chosen one topic which is very close right now to my heart. As I said, as a mediator and as a scholar, I do some research, and the research is connected with that specific kind of mediation that you can conduct in the civil law cases. But the specificity of that mediation is the fact that on one side, one party could be that public entity. By public entity, by that I understand the public finance sector entity. So, and one more general remark when it comes to my speech. In Poland, the administrative division in Poland looks like that Poland is divided into provinces, then provinces are divided into districts, and districts are divided into communes. So when I talk about public finance sector entities, I talk about in most cases, I talk about those communes And I talk about those districts as they receive some public money, for example, to build, I don't know, schools, to build swimming pools, or to build roads in their communes, in their districts, right? So I'm going to talk to you today about those specific kind of mediation between those public finance sector entities. For example, communes that build roads, and those roads weren't created well enough to use them. So they made a dispute in the civil law court to receive some money back. So these are the mediations. I'm going to concentrate on mediations between public finance sector entities and between entrepreneurs, companies, corporations. So these are, it is very important to understand that I'm going to talk about the civil law mediations, but the specificity of that is that on one side we have that public finance sector entity, on another, the other party is in most cases entrepreneur, some kind of company or corporation that was cooperating on the basis of the civil law contract with that commune, with that district. They had a contract, the public money were involved, but the contract didn't go well. And there is a civil law dispute case. There are some dispute civil law amount of money that the, for example, district or the commune wants to get back. What inspired me to choose that topic? First of all, the practical side of my job. So all observations that I made during mediations, and in most cases I deal with court annexed mediations. Every single year I do like 120 of them. Among them, there are those mediations where I have those public finance sector entities. So all observations and various experiences related to those observations, the talks to attorneys, to lawyers. How do they prepare to those mediations? How do they conduct mediations? Why do they reject mediations? And so on and so on. And from the theoretical point of view, something that inspired me is the wording of Article 54A of the Public Finance Act, because Public Finance Act allows those public finance sector entities to take part in mediation, and this is not against all of those public finances rules. It is in favor of those rules if public finance sector entity fulfill at least one important requirement. That requirement is connected with something that we call a written assessment of the effects of concluding future settlement. From my perspective, it looks like that written assessment, the requirement of a written assessment is connected in a simple way with preparation to mediation. I observe the situation that if public finance sector entities prepare well to mediation, if they prepare the needed by law written assessment of the future settlement, they are prepared better to mediate their case, and they more willingly cooperate on a future settlement. The wording of Article 54A of Finance Public Act says, and I would like to read that part, that a public finance sector entity may conclude a settlement on disputed claims under civil law. So once again, this is not an administrative procedure, but we are talking about the civil dispute. If it is assessed that the effects of the settlement are for the unit, or respectively the state treasury or the budget of a local government unit, more favorable than the likely outcome of court or arbitration proceedings. So Polish law, once again, allows public finance sector entities to take part in mediation procedure, in that civil law mediation procedure, and try to get back some money that were spent on roads, on, as I said, schools, hospitals, and so on and so on, if that public finance sector entity proves that it's better for them to take part in mediation than go to the court or take part in arbitration. The second part of Article 54A of the Public Finance Act explains that the effects of the settlement will be assessed in writing, taking into account the circumstances of the case, in particular the legitimacy of disputed claims, the possibility of satisfying them, and the expected duration and cost of court or arbitration proceedings. Which means that the public finance sector entity should have a written assessment, a written preparation, a written proof that taking part in mediation in that civil law case is better for them than taking part in court proceeding or arbitration proceeding. And of course, this is everything that we can find in law. But if you think about the specificity of public finance sector entities, you can imagine that for them it is not enough. There are so many questions that are left without answers. For example, who should prepare that written assessment? Where should it be prepared? When should it be prepared? It is not actually mentioned that it should be done, they should do that before taking part in mediation. How to do that? How specific to be? So from my perspective as a mediation and from my perspective as a scholar, I can ask myself or the whole Polish legal system, what are the necessary elements of the written assessment? What is the time for its implementation? And due to the fact that mediation is a flexible process, if there is a lack of this written assessment, can this gap be corrected during mediation? If yes, by who and how to do that? So asking myself all of those questions, asking those questions to lawyers that were taking part in my mediations, I created a research problem that I'm dealing with. So can we treat, first of all, I was thinking whether we can treat the written assessment as a good method of preparation to mediation, and what is the impact of that written assessment for mediation. In other words, my hypothesis is whether a properly prepared written assessment of a settlement could have a positive impact on the effectiveness of the parties' participation in mediation process. And the purpose of my speech is to concentrate on the written assessment, thinking about the written assessment as a good kind of preparation to mediation. I would like first to tell you a little bit about those elements that from my perspective as a mediator, as a practitioner, should be included in that written assessment. Then I would like to share at least one experience connected with conducting mediation with the public finance sector entity. And then I would like to finish with some conclusion remarks connected with benefits, risks, consequences of having that written assessment. So first of all, let's start with those elements that from my perspective should be included in that written assessment, so that preparation to mediation. And of course, I'm talking about public finance sector entities, what they should take into consideration. But if you want, you can use that structure that I'm going to present to you more global. I think everybody, every party, no matter whether they are public finance sector entity or not, should take into consideration those elements. So if I were a lawyer representing public finance sector entity in mediation procedure, if I had to prepare that written assessment, I would draw up a specific plan, let's call it a table or a chart, that would be divided into 4 parts and would divide like at least 4 elements. First of all, I would add there one element that is connected with legal and economic conditions for pursuing a claim. Then the second element that I would include in that chart would be possible and accepted goals or effects of conclusion of the settlement. The third one will be the methods of obtaining satisfaction of claims as alternative to concluding a settlement. And the fourth one, the one that the related commitment of resources. So when we think about those legal aspects that could be included in that chart, in that table, which is that written assessment, first of all, I would think about some facts with reference to source documents, of course, so to contracts, claims, yes, and try to justify them. Then I will add some recognition of the legal and factual legitimacy of the disputed request, including, for example, the occurrence of circumstances that are the basis for calculating the amount due, or the one that shaped the claim, such as contractual penalty, title, basis for the claim, etc. And then, which is from my perspective as a mediator, the most important part of the legal aspects included in the written assessment, I would present the possibilities of potential satisfaction of the claim, taking into account the possible financial situation, not only of my client, so that public finance sector entity, but also the possibilities of satisfaction of the claim of the other party. From my perspective, this is very important, that part, because sometimes when parties sit and when we talk during mediation procedure, the parties have those goals that are unachievable. They want the money right now. They don't think that the other party cannot pay due to some different reasons or circumstances. For example, the situation, the political situation, the war in Ukraine, yes, the global problems, financial problems, all of those aspects affect the way how entrepreneurs mediate cases. And public finance sector entities, when calculating the money that can be received from an entrepreneur, should take into consideration all of those aspects. That sometimes it's better to wait or receive the smaller amount of money, or split the amount of money into several pieces, instead of going to the court, receiving in the judgment the full amount of money, but in practice do not receive any money, because then an entrepreneur cannot pay them. So this part of legal aspects that should be put in written assessment, so looking not only from my perspective but from the other party's perspective, whether that party can satisfy the claim, is very important. And then, of course, when it comes to legal aspects, I would add also estimation of the expected or probable duration of court or arbitration proceedings. If that written assessment should show the advantages of mediation, it needs that comparison with the court proceeding and arbitration. Of course, it would be great if that kind of estimation of the expected probable duration of court or arbitration proceeding could be supported with the reliable data. If you want to know, in Poland, that the most recently statistics shows that an average court proceeding, civil court proceeding takes 18 months, which is a year and a half. And of course, this is an average, because in my cases, and I mediate in Podlasie region, this is northeast part of Poland. Last week, I had entrepreneurs and public finance sector entities that were waiting for the first hearing for the whole year. So for the whole year, they couldn't receive money. They couldn't do anything with their claim. They were just waiting for the first hearing, and it took them a year to go to the court to meet first. Tomorrow, I'm going to have a mediation, online mediation, with public finance sector entity and with entrepreneur, and they've been in the court proceeding for more than 2 years when they decided on mediation. Okay, my time is almost, I'm almost done. All I promise I will finish in those 4 minutes. So apart from these legal aspects, of course, financial and aspects, as I said, should be taken into consideration. So when it comes to economic and financial aspects, of course, calculation of the expected costs of court or arbitration proceedings or a financial and personal nature costs should be taken into consideration. And of course, if there are any costs, presentation of expected potential financial or organizational and time effects of concluding a settlement. And then, of course, the comparison of all of these data should be done, the calculation of profit and losses, and on the basis of that, the written assessment should be created and it should be presented to the public finance sector entity, showing the advantages and disadvantages, the possibilities and chances of taking part in mediation rather than going to court or arbitration. When it comes to, so these are all of those elements that could be included in written assessment. When it comes to the examples and my experience when it comes to that written assessment prepared by the public finance sector entities, my experience shows that all public finance sector entities that are represented by lawyer who take part in mediation and who do that written assessment before coming to mediation are better prepared and are better organized and are taking part in mediation that more how to say it, more willingly. They look at the other party's needs, and this is in contrary to the situations when public finance sector entities or the representatives, lawyers who come to mediation says, come to mediation and say, yes, we know we need to prepare written assessment, but you know what, let's first take part in mediation procedure, and then if it happens that we settle, we will create that written assessment. That does not work. So my conclusion, when it comes to that preparation to mediation, and in the context of public finance sector entities, it is called the written assessment. From my perspective, that written assessment can have a positive impact, of course, provided that it is prepared with those key elements, is carried out before the start of mediation, and allows for flexibility. And of course, if it is prepared by both parties, not only by public finance sector entity, but also by entrepreneur. It can also broaden and change the perspective of both parties. It can influence the limits and those borders, those mediation borders of each party. From my perspective, the written assessment that is prepared before mediation procedure shapes effective negotiation attitudes, and of course facilitates the work of mediator. So, and altogether allows the parties to work effectively. So from my perspective, that kind of written assessment should be carried out before each mediation proceeding. I don't know whether we should regulate it more by law, as the whole mediation process is a very flexible one, but for sure it should be some kind of custom that we can use. And for sure, our lawyers, the lawyers that represent not only public finance sector entities, but also entrepreneurs or other different types of individuals, should take into consideration of preparation of this kind of written assessment. Thank you very much.
Thank you so much. Thank you for being on time, as usual. The next speaker I would like to invite is Dr. Andrea Spada Jimenez from University of Malaga. She's professor of procedural law at the University of Malaga and also the author of several publications. She has coordinated other works in Spanish and English on the current procedural system, as well as authoring journal articles on international jurisdiction and competence, universal jurisdiction environment, and voluntary jurisdiction, among others. Today, Dr. Andrea will present the speech entitled Mediation as an Effective System to Protect the Environment. So the floor is yours, and you have also 20 minutes. After 15 minutes, I will show my face, as Professor Gieruszyńska said. The floor is yours.
Thank you, Alexandra, and good afternoon, everyone. So first of all, before beginning, I would like to thank you for allowing me to participate in this Congress. Thank you so much. Today, I'm going to present my research on environmental conflict resolution systems. Specifically, I'm going to focus on whether it is effective to apply mediation to resolve environmental conflicts. I'm going to address this issue from an international and general point of view, taking into account that it is a matter of a universal and transversal nature. And for this, we must take into account that we are currently facing a climate emergency caused by development and a production system that is not sustainable. However, the need to act through global action on the part of all states in the achievement of sustainability to avoid the effects of climate change has been raised for 3 decades now. However, states have approved various well-known international instruments such as the Rio Declaration 1972, Paris Agreement, Agenda 2030 in achievement to the Sustainable Development Goals. Well, we are advancing step by step in the achievement of a more sustainable system for the protection of the environment. But if we now reflect, we have been adopting instruments that nobody complies with for decades, and it is the reason of the current climate crisis. Therefore, we need to consider applying judicial mechanisms that guarantee compliance with these instruments. If we delve into Taruffo's doctrine of what an effective justice system is, it determined as one in which there is an effective judicial system. And what is an effective judicial system? Taruffo established that an optional procedural system is one in which the procedural law is rational, both in the sense of coherence and in the sense of instrumental functionality, with respect to the purpose that are considered proper to the administration of justice. In view of this, in order to guarantee the right to effective judicial protection, it is necessary that the procedural channels show these characteristics of rationality, coherence, and instrumentality in accordance with the social reality and the responsibility to protect that the state holds towards its citizens. Well, why is the procedural system, therefore, not efficient for the environment? In the case of Spain, we can observe that there is a fragmentation of the process or proceedings, which means that the proceedings that have been configured for a certain matter, that is to say, to protect certain groups, do work well enough to determine that they are effective and enjoy the so-called privileged judicial protection. However, in terms of the environment, no specific system is regulated, so which means that it must be governed by the general system, and the general system has many absences. And this is a problem, especially since various reforms are carried out to guarantee the specialization for other citizens and certain groups of procedures and the process in general. So it remains patched, with numerous of legislation to apply and which is complex, which generates legal uncertainty and inefficiency. This also means that the process is delayed because specialties similar to the subjects are not foreseen. How can a process to resolve a conflict be effective if financially and mentally it exceeds what is bearable? One must think that in the environment we will generally find a party that is the one that causes the damage, which may be a company, and another party that may be a subject or a group of subjects affected by the environmental damage. That without a specialized system, the subject, the one with greater economic capacity, will benefit more than the system will be more ineffective for the victims, because obviously it's inadequate system for victims against the big companies, for example. Therefore, taking the above into account, we should determine if the mediation could be effective in the different branches: administrative, civil, and criminal. In administrative terms, on the one hand, access to justice, and on the other hand, administrative procedure must be divided. If we investigated about access to justice, is limited because it is an access to justice limited to associations and foundations in defense of the environment in general, except that when we access justice as a natural person in defense of an individual interested, but we need to prove the individual interested lesson. We should demonstrate that indeed the individual interests have been violated. Therefore, we find that in accordance with the Aarhus Convention and Regulation 2006, on the other hand, with legitimacy only for association and foundation in defense of the environment and to obtain that protection from the environment, but not for the rest of natural persons. So all this is derived from the Aarhus Convention and the regulation of the European Union that determines the action or omissions that harm the environment. Therefore, it would be ideal to develop a system of collective and preventive participation in which the administration, when it proceeds to carry out an activity that could harm the environment, I think mediation could be developed as a form of citizen participation before it began, a procedure that will guarantee us, on the other hand, that the public administration will put itself in the role of citizen, and the citizen will also put themselves in the role of public administration, as well as could be achieved by obtaining the advantage of developing an activity with the most respectful administration with the environment. Now, for this, we should have a mediator, a specialized technical specialization, with a technical specialization in the matter, because we could run the risk that the administration, by its own superiority, abuses carry on out a mediation prior the activity, and it will also be possible to think that mediation prior to the activity that undermines the environment and will no longer close the paths of citizens who have already been part of the mediation, will not close the paths to be able to claim. I understand that not due to the very nature of mediation, what it will generate will be a participatory procedure for the development of activities that could harm the environment, but in no case could it be considered that it has a res judicata effect for the future if these activities are carried out in another way, or if the mediation agreement is violated by the administration or the company. However, in terms of legitimacy and access to justice in relation to the content of regulation, in Spain, we can find a law 26 2007 on environmental responsibility that provides for that law according to European Union, which it provides is to guarantee that the administration is the who bears the responsibility when the environment is because he has the duty of governor. Therefore, as administration bears the responsibility. If we thought of applying a mediation system, we will have the subjects, those whose right to a healthy environment. On the other hand, to the company that causes the damage and or to the administration. The law does not provide for a specific mediation system, environmental system. Within a specific procedure. Rather, the only thing it provides the law is that a procedure that has been initiated against companies and subsidiarily against the administration can be finalized. An agreement has been reached between the parties, but we are not specific how this agreement is to be adopted or if a third part could intervene in it, with which or it will be convenient to regulate the mediation system as a form of termination of the process, with certain rules and characteristics in which it is, I think, is guaranteed that one party is not abused over the other party. So I think the characteristics of mediation that we need to create an environmental mediation, we need to account certain characters. Obviously, this mediation will be a flexible system, voluntary, confidential, collaboratory. The mediator enjoys impartiality and neutrality. It is up to the mediator to guarantee a balanced participation of both parties, respecting their points of view without using any judgment and without offering situation at any time, since they must be the ones who with their help reach agreements. To this note, we must add one more to the fact that when dealing with environmental mediation, it will entail a specific requirement for the mediator, such as a technical qualification. Since due to the specificity of the matter, it will require that they have technical experience of the problem to be dealt with. By understanding the complexity of the phenomena, he can help identify options or criteria that have worked in similar cases and will be able to guide the parties toward finding solutions and reaching consensual agreement. This technical qualification can be derived from professionals who are dedicated to the environment and who want to train as mediators, which although it is desirable, will not always be the most common. That is why training and experiences will play a key role in this type of mediation. I think is the key of the efficiency of this type of mediation. So, with respect to the mediator, we need to know that the figure of mediator is essential. It's essential because mediation does not seek to find the objective truth, but to find an agreed solution that recognizes and is based on the perception and experience of all parties. When direct negotiations fail and the lines of communication between two parties are broken, then there is room for a third party to intervene. However, beyond the coincidences in definitions, three mediation models can be distinguished: the harbor, the transformative, and the narrative, of which the following characteristics stand out. The harbor model proposes an approach where the parties work collaboratively to solve it. It is oriented to obtain satisfaction of the interests. The mediators control the interaction. The process is structured, and the third parties are generally represented as experts in directing the discussion. On the other hand, the transformative model is orientated towards communication and interpersonal relations of the parties. For the creators of this model, the objective of mediation is not agreement, but the development of people's potential for change by discovering their own abilities. They focus on human relation with the intention of fostering moral growth. For its part, the narrative model has the objective of reaching an agreement, but with the emphasis placed on communication and the interaction of the parties. The Harvard model equates mediation with interest-based negotiation without valuing feelings or relationships, while the transformative model seeks to develop skills and attitudes in the parties that allow them to manage their conflicts more constructively. Finally, Sarah Cobb's circular narrative model of 1994 also recognized that the biggest challenge lies in recognizing the perspectives, needs, and interests of all parties, which also pursues and ends similar to interested-based negotiation. However, the emphasis is placed on generated different conversations that allow perspective change in the parties. The focus is on circular communication to achieve the objective of changing the relationship of the parties so that they can incorporate the perspective of the enemy and reach an agreement. In situation of conflict or disagreement, the involvement of a third party who is not involved in the conflict and is perceived as impartial by all parties may be useful. This person or team of people can focus on ensuring that all participants feel heard and encourage the search for creative solution. In the same way, the parties will have confidence in him to reveal information that would otherwise never tell his adversary, and he can even offer solutions that he has had the opportunity to witness in similar cases throughout his experience. So the mediator has techniques to overcome barriers that may arise between the parties, one of which is to redefine the conflict as a shared challenge, or to remember the cost that will entail a prolongation of the problem, to provide scientific reports that are objectively accepted by the parties, that he be the only guiding thread of the story to avoid based accounts and circular and destructive conversation. So they have different characteristics: neutrality, impartiality, multi-partiality, and we need to know that the environmental conflicts that are more complex than other conflicts. So taking into account the exposed mediation can be applicable in any field. However, if we deliver it into the civil and criminal system in Spain, we find the following. Regarding to the civil system, we only can find a general system, but no a specific system of environmental mediation, only a general system of mediation. And it's I don't know, it's so specific to resolve the dispute in environmental conflicts. And regarding the criminal procedure system, will it be effective to contemplate a dismissal of the process for reasons of opportunity? Maybe. I understand that it will only be effective in the event that a repair of the damage is guaranteed. But how do you do we guarantee that repair? Perhaps companies, if mediation could be carried out, will not think about contaminating the same way. And I understand the damage as an externality because they will not have a penalty beyond economic. So would you think that applying a penal mediation system is effective, or criminal mediation system is effective? So I don't know, from my point of view, no. In conclusion, therefore, we can determine that it's necessary to look for effective systems that ensure the application of regulation and therefore the protection of the environment that do not exist in Spain. Either special jurisdictional procedures or alternative conflict resolution systems such as a mediation, but I understand that mediation can be effective for decision making by the administration because it can take citizens into account, but it will lack its voluntary nature and we should make it mandatory, with which it already loses part of its own nature. So it's difficult. On the other hand, if we determine the application of a classic mediation system and not suitable for the environment, the parties will be in different positions and perhaps it will not be effective because there will be an abuse of the strong parties such as companies or administration over the weak party. What advantages will mediation have? Yes, resolves conflict much faster than through a judicial process with cheaper costs and more affordable and citizen-friendly system, with which mediation can be good as long as it is carried out in a special way and with specialized environmental entities. So with this, thank you for your attention and for the opportunity to allow to participate. Nice to be here. Thank you, Alexandra.
Thank you so much, Andrea. Thank you very much. The next speaker is from Vilnius University, with which we have a great cooperation for years. I would ask Dr. Neringa Gaubienė to have a speech. She's lecturer at Vilnius University Faculty of Law in Lithuania. She's also a member of research group of Vilnius University Faculty of Law, Interaction between Private Law and Digital Technologies. Dr. Neringa will give a speech according to possibility of active use of mediation in context of the execution of enforceable titles. So, Dr. Neringa, the floor is yours. You have also 20 minutes. After 15 minutes, I will turn on my camera.
Good afternoon, ladies and gentlemen. Good afternoon, organizers. I am honored to give this presentation about a topic which is great importance in the field of alternative dispute resolution, and it's called possibility of active use of mediation in the context of the execution of enforceable titles. First of all, enforceable titles refer to court judgments, arbitral awards, or other legal instruments that can be executed or enforced to secure compliance with the underlying decision or obligation. In era where conflicts arise frequently, it is crucial to explore innovative approaches to resolving disputes. Mediation, with its potential to create sustainable and amicable solutions, could be also used in the enforcement process. The central role in the enforcement process is occupied by bailiffs or enforcement agents. A bailiff is an officer of the court responsible of various tasks, including serving legal documents, executing judgments, and enforcing court orders. Their role is to carry out the instructions of the court and ensure that the court decisions are implemented. However, if there are specific circumstances where a bailiff is involved in facilitating communication or resolving minor disputes during the enforcement process, it would be an exceptional situation and not the traditional role of bailiff. The discussion about whether enforcement agents should be allowed to act as mediators is extremely relevant in the present trends, especially in the context of providing additional commercial service in general. This is not surprising because enforcement agents may be ideal mediators due to their training and practical experience requiring all kinds of legal and social skills. For many years, the profession of enforcement agents has been active in the field of mediation due to the nature of its functions. It was recognized that enforcement agents, because of the qualities of impartiality, neutrality, and confidentiality inherent to their function, appear to be the ideal professional to act as mediators in the context of alternative dispute resolution. In the daily practice, bailiffs play a crucial role in the resolution of disputes. Enforcement agents face the challenges of reconciling two conflicting interests. On one hand, they strive to satisfy the creditor's desire to recover what is rightfully owed to them based on the legal enforceable document. On the other hand, they encounter debtors who may be unaware of, unwilling to fulfill their obligation and settle the debt imposed upon them. In the context of the mediation awareness and training program for enforcement agents, ensuring the efficiency of the judicial refer to mediation, we can also find that enforcement agents must be able to communicate in a fair and balanced manner in order to carry out their mainly judicial mission, but also regularly in their accessory mission, such as, for example, amicable debt collection. It is therefore essential that enforcement agents have a full knowledge and understanding of the process and the benefits of mediation, not only to practice so-called post-judicial mediation, but also to be able to act as mediators in a broader sense in the context of alternative dispute resolution. It's important to note that the use of mediation in the enforcement process is contingent upon the consent of the parties involved and the specific circumstances of the case. Although mediation is not typically employed as a direct tool in the enforcement process, there are instances where it can be leveraged to facilitate the resolution of enforcement-related matters. In some jurisdictions, there's a growing trend towards the active use of mediation in enforcement process. Enforcement agents may function as mediators in a selection of European states, such as France, Belgium, Italy, the Netherlands, Portugal, Switzerland, Spain, and also Lithuania. In the jurisdictions mentioned, enforcement agents can often be qualified as private enforcement agents. That is, they do not act as civil servants. Such private enforcement agents who have independent status often provide additional services of a commercial nature next to enforcement, such as amicable debt recovery, the provision of legal advice, and many more. In recent years, they have also started to offer their services as mediators in various types of disputes. In 2009, Council of European Commission for the Efficiency of Justice adopted guidelines for a better implementation of the existing Council of Europe's recommendation of enforcement, where they stated that the enforcement process should be sufficiently flexible so as to allow the enforcement agent or bailiff as a reasonable measure of a latitude to make arrangements with a defendant where there is a consensus between the claimant and the defendant. Such arrangement should be subject to through control to ensure the enforcement agent's impartiality and the protection of the claimant's and the third party's interests. It is within this context that post-judicial mediation is explicitly mentioned. To sum up, there are all prerequisites for mediation in the enforcement process. Mediation carried out during the enforcement of a court decision or an enforceable title, it is called post-judicial mediation. International Union of Judicial Officers calls post-judicial mediation as a method by which the enforcement agent tries to obtain an arrangement from the parties by negotiating either a payment plan or obtain a remission of interest or even obtain a reduction of the debt against a payment of the negotiated sum. Post-judicial mediation is often not conceived as mediation in the strict sense. That is the bringing about of an amicable settlement under the guidance of a neutral mediator, but as a series of activities aimed at providing efficient and effective enforcement services. It is often better to refer to post-judicial mediation as participatory enforcement or amicable enforcement. The Global Code of Enforcement of the International Union of Judicial Officers also called post-judicial mediation as soft enforcement. Mediation can be a useful tool in debt recovery services, particularly in situations where both the debtor and the creditor are open to negotiate and to go to compromise. Mediation involves a neutral third party who works with both parties to help them reach a mutually agreeable decision. In debt recovery, mediation can be used in numerous ways. For example, post-judgment disputes. After court decision has been made and enforcement actions are underway, conflicts or disputes may arise between the parties involved, of course. Mediation can be used to address these issues and find mutually agreeable solutions without the need for further court intervention. Negotiating repayment plans is also on the plate. In cases where the enforcement involves the collection of debt or monetary judgment, mediation can be used to negotiate and establish repayment plans that are accessible to both the judgment creditor and the judgment debtor. Mediation can help parties find a payment agreement that takes into account the debtor's financial situation while still satisfying the creditor's interests. Also, mediation in the enforcement process can be used as exploring alternative options. Mediation can be used to explore alternative options for debt recovery, for example. Resolving implementation challenges. Sometimes there may be practical challenges in implementing certain aspects of a court decision. Mediation can help parties identify and resolve these challenges just by fostering dialogue and exploring creative solutions that meet the underlying objectives of the court decision. Overall, the active use of mediation in debt recovery services can provide a number of benefits, including faster resolution of disputes, reduces cost, improves relationships, and so on. It's important to note that the availability and applicability of mediation in the enforcement of court decision can vary depending on the jurisdiction and the nature of the case, of course. The use of mediation in the execution process can offer several benefits. Of course, creativity in problem solving. Mediation allows parties to explore alternative solutions beyond the strict enforcement of the court decision. And mediation is well known for its time and cost efficiency. Mediation can potentially save time and cost associated with prolonged litigation and enforcement procedures. By resolving disputes or implementation challenges through mediation, parties can avoid or minimize the need for further court proceedings and associated expenses. Also, it's very important to talk about how to stimulate, how to foster mediation in enforcement procedure. So, to stimulate the use of mediation in the enforcement process, various strategies can be employed. Here are some approaches that can help promote and counter the utilization of mediation. First of all, legislative support. Legislative bodies can enact law or amend existing legislation to explicitly recognize and promote the use of mediation in the enforcement process. This law can provide incentives or requirements for parties to consider mediation before or during the enforcement proceedings. Additional legislation can include provision for the enforceability of mediated agreements, giving parties confidence in the process. Also, education and awareness, raising awareness about the benefits of mediation in the enforcement process is crucial. Educating judges, lawyers, enforcement officers, and the general public about mediation's advantages can help dispel misconceptions and foster a better understanding of its potential. Conducting training programs, workshops, and seminars on mediation can also equip professionals with the necessary skills and knowledge. Mediation programs and services, establishing specialized mediation programs or services dedicated to handling enforcement-related disputes can facilitate access to mediation. The programs can be administered by court system, alternative dispute resolution organization, or public entities. Also, integration into enforcement process. Mediation should be integrated some kind of. Integrated mediation to existing enforcement process and practices. This can involve incorporating mediation clauses in enforceable titles or court orders, establishing mandatory or voluntary mediation requirements, or setting up a mediation tracks within the enforcement process. Of course, financial incentives is essential for fostering mediation in enforcement process, and governments or relevant institutions can provide financial incentives such as fee waivers or reduced fees to parties who choose mediation and others. Efficiency in the enforcement process may be considered as a cornerstone element which allows us to maintain justice and order in society. This is particularly true of the rapid digitalization of various areas of law, including the enforcement process, where new technologies and online platforms have provided new opportunities. And the regulation proposed in the Global Code of Digital Enforcement, adopted by the International unit of bailiffs and judicial officers introduces us with online mediation in the enforcement of court decisions. And in Article 15, it is stated that national law should allow judicial officers or enforcement agents to offer an online mediation, including post-judicial or amicable debt recovery service. Judicial officers or enforcement agents should benefit from secure platform to perform online mediation in the context of the execution of enforceable titles. And in the conclusion, mediation is an important instrument in making debt collection more effective, since it takes into consideration the financial situation of the individual debtor and allows the debtor to influence the enforcement process. Research, education, and collaboration are essential to unlock the full potential of mediation in the enforcement process. Thank you very much. Your questions are welcome after all discussions, after all presentations.
Thank you very much, especially for being in time. Last but not least, presenter is Jan Holas from Masaryk University from Czech Republic. Jan Holas is an assistant professor at Masaryk University Law School, where he works on civil procedural law and mediation. He also worked with the Supreme Court of the Czech Republic and the Mediation and Education Center Brno. Today, the topic of his speech is limits of coercion to mediate. So, Jan, the floor is yours. You have 20 minutes. After 15 minutes, I will turn on my camera. That means that 5 minutes left. If you want to share presentation, you can, of course, share the presentation. You have the special button upside of the screen. So the floor is yours.
Thank you very much, Alexandra. I first of all try to share the presentation.
We can see you, we can hear you, so just presentation left. Okay, and now we can see presentation, so everything is perfect. The floor is yours.
Great. Once again, good afternoon to all of you from the Czech Republic. First of all, I apologize for my informal closing. I have been traveling all the day and I arrived home about half an hour ago, but I didn't want to miss this seminar on such an interesting and useful topic as mediation is. I have prepared a short paper for you on the limits of coercion to use mediation in civil cases. The limits of coercion to mediate can be understood as an extent to which parties to a dispute can be forced to use mediation without distorting the conception of mediation or other conceptions. This issue is particularly important in conceptual considerations regarding mediation, for example, in legislative considerations about setting up a system of approach to mediation in a given country. But let me begin by noting that there are different countries, different states may have different models of coercion to mediate. There are states in which mediation can be mandated, mandatory mediation, either generally by law in all cases or individually. It can be it can be imposed by a court in a particular case. And similarly, in some countries, it is also possible to order so-called meeting with mediator. In this model, it is not an obligation to initiate mediation. but to meet with the mediator in order to obtain an information about mediation and to offer to initiate mediation. Even this obligation to meet with mediator can be imposed generally by law or by court in specific cases. The last type of model is voluntary mediation. In states with this model, it is up to free will of the parties to the dispute whether to initiate mediation. In the first two models, in mandatory mediation model and mandatory initial meeting with mediator, there is a risk that the obligation imposed to the parties of the dispute may interfere with mediation, but also with guaranteed fundamental rights and also with civil court proceedings or principles of civil court proceedings. For this reason, it appears important to define the limits of coercion to mediate in relation to these three areas, because all three may be negatively affected by coercion to mediate beyond a certain level. Limits on coercion to use mediation can be seen as boundaries that the legislation should not exceed, so that the values and principles of the concepts concerned are not unduly interfered with. Yeah. So let's start with the first area, with the principles of mediation. The most important principle that can be limited by compulsory or mandated mediation is the principle of voluntariness. In the literature, the principle of voluntariness is often understood as voluntary entry and participation in mediation, no pressure to resolve the dispute. Parties define the subject matter and the form of dispute outcome, and also ability of the parties to refuse to agree, the ability to access or reject a particular outcome. However, there are strong opinions in the literature that this pure definition of principle of voluntariness of mediation does not hold up. Two levels of coercion are distinguished. It's coercion into mediation and coercion within mediation. Coercion into mediation means coercion to initiate mediation. And in contrast, coercion within mediation means coercion to conduct mediation and eventually to conclude a mediation agreement. In most cases, coercion into mediation, or let's start maybe with the second one, coercion within mediation. It will be shorter. A coercion within mediation would be a violation of a very core of the principle of voluntariness, and therefore its violation would be contrary to the basic postulates of mediation. So the coercion within mediation is principally prohibited. However, coercion into mediation, it means to initiate mediation, will not undermine the concept of mediation in an unacceptable way. Such coercion usually acts as motivation to initiate mediation, but the parties to the dispute retain the option to terminate the mediation at any time. The literature concludes that coercion based on categorical or random ordering of mediation or disproportionate sanctions for a refusal to mediate and excessive supervision would be an unacceptable distortion of the conception of mediation, but some form, on some level, to coerce, to start mediation is acceptable according to many authors. So to conclude this area, coercion into mediation in contrast to coercion within mediation could be acceptable and may not unduly restrict the principle of voluntariness and conception of mediation. Now the second area of limits are guaranteed fundamental rights. Forcing mediation needs not only distort the conception of mediation itself, it may also result in a restriction of the guaranteed fundamental rights. In particular, the right of access to the court. In other words, mandatory mediation may prolongate the access to the court. In its case law, the Court of Justice of the European Union has already dealt with cases of mandatory mediation and defined the following limits. The limits are that mediation must not lead to a decision that is binding on the parties, then that mediation does not lead to a substantial delay in bringing the action to court. Mediation stays the limitation period in the rights in question. Mediation does not result in cost for the parties, or its costs are insignificant for the parties. Electronic form is not the only way of accessing mediation, and in exceptional cases where the urgency of the situation so requires, preliminary rulings may be issued. So this is the limits of the second area. And let's see also the final one, and it's principles of civil procedure, because the coercion to mediation may also limit this area, the civil procedure, we can say that the most significant risk in this area is the inconsistency of the coercion into mediation or informative meeting with the conceptual notion of civil litigation. In the continental legal culture, the civil process serves to protect subjective rights, which is usually secured by the court's decision on the case. Amicable resolution is desirable and open to the parties, but it is neither the purpose of the civil procedure or civil process, nor the role of the court to force the parties to resort to other means of dispute resolutions to resolve their disputes if they are not interested. However, the situation is different in non-contentious proceedings, where greater court intervention in the public interest may be appropriate. Leaving aside the conceptual level and looking at the positive law level, the mere coercion to initiate mediation or an informative meeting with a mediator does not limit the dispositive principle, as it is an ex officio procedure in proceedings conducted by the court. However, it may be limited by the related imposed stay of the proceeding. If, however, the coercion pursues a legitimate aim in the system in the system in question, and if the stay of proceedings is not unreasonably long, the restriction of principle of disposition or dispositive principle will not be disproportionate. Coercion into mediation can contribute, in contrast, to an amicable conclusion of the case and to procedural economy. However, these aspects should be examined in more detail for each specific instrument of coercion. If the instrument is not effective, it may, on the contrary, contribute to prolonging and delaying the proceedings. It should be added that only the limits, as we talked about in these three areas, within which it is appropriate to keep legislation or legislative action, it's only limits, it's only boundaries, we can say. But the next step to be considered is the effectiveness of the measures chosen. A lower level of coercion is usually preferable, and a system in which there is some positive motivation for positive initiative for the parties to the dispute to choose mediation for the dispute resolution, for example, free provision of mediation, etc., without recourse to coercion seems ideal. The presented topic is very extensive. So my contribution was only a brief summary of limits of these three areas which could be distorted by a coercion to mediation. For details, I can refer to the text published in this book, and it's the end from my side. So thank you very much for attention, and it was nice to be here with you. Thank you.
Thank you very much, especially for being in time. This was the last presentation for today. So if you have any questions, because I was observing chat and I saw that there were some questions to Marta Kuklo. So if you, Marta, maybe if you want to add something to your written answer, this is the time. This is also the time to have the questions. If someone of you wanted to ask the question, I know that you don't have possibility to turn on microphone. Please raise hand, and I will give you the possibility to ask the question. Marta.
Thank you, Ola. Yes, there was this question from Sam about how we should understand that written assessment that I was talking about. So using chat, I was trying to explain that the written assessment is not the same thing as the mediation brief. The written assessment, I would say, is some kind of written preparation to mediation, and it should be done by a lawyer or in the group of lawyers and, for example, financial experts that are working for that public finance sector entity. And it is not presented to the mediator, but this is presented more to the public finance sector entity or people who are in charge of this public finance sector entity, so that they could know why, what is the reason, what are those limits, those borders in mediation that they cannot cross and what will be the scope of the mediating issues. In other words, whether it is worth to mediate or whether it's better for them to go to the court.
Thank you so much. Thank you. I completely agree with you. Do you have any other questions, or maybe do you want to add something to your presentation or to the presentation of our speakers? Okay, I don't see any questions, so I will try to sum up today's seminar. Today we heard about mediation finally from the, oh, okay. I saw one raised hand. Is it still actual? No? Ah, so I'm raising hands, sorry. Mukama, okay, I will give you the voice. Okay, please. Sorry. Okay. Mukama Agustin, you want to add something? You should mute. You are muted now, so you should.
Can you hear me?
Yes, now we can hear you. Yep.
Okay. Oh, maybe you want to see me too.
In a moment, for sure. Yeah.
I don't know. Is it?
Yes,
Is it important?
Yep, we can see you and we can hear you.
Yeah. Okay. Thank you. My question. Okay. I first of all thank you for the organization of the seminar. It was very good, and all the themes are very interesting, and all the presenters. It was really very helpful. So my question, to be brief, is about the last presenter, about the coercion to mediation, the limit. So to one part, he said that the mediation can be limited by the preference of the parties to prefer an amicable settlement. So I think it can be dangerous if a mediation has been decided either by the court or by agreement, and then parties prefer in the process to start by settling the case amicably. I think it can negatively impact on the future of the mediation in case that settlement is not successful. If they are not settled and they come back to mediation after failing to settle the case amicably. So because they will be having, if they come back to mediation after, they will be having already positions which are very hardened, and mediation risk of failing because that tentative of to do an amicable settlement have hardened their position, each individual position, and the mediator can find himself in a position where he's trying to negotiate, to settle, to make them be flexible, and find that each party, because of the amicable settlement which has failed, have already hardened their position, and they don't want to mediate anymore, to accept an amicable, not an amicable, but to have the process of the mediation be taken to an end successfully. So that's my position. So I wanted to ask him if he sees it like that, if it can be encouraged, if it can be really a limit, or if that possibility can be excluded once the mediation has been decided to take place. Thank you.
Thank you so much. Jan, I think that this is question addressed to you, and also on the chat, we have second question. So if you can answer to these two questions, it will be great.
Only for a specification, may I ask, so you are in favor of coercion?
No, I am not in favor of having a coercion to stop mediation taking place because of a certain principle, a certain preference for the parties to go into amicable settlement. Because if they fail, that's what I was saying. In case the amicable settlement fail, then mediation will be more difficult to have to be successful. So once mediation is decided, anything else should not come in between before the mediation fails itself.
I'm not sure I get it well, but the conception I have presented comes from our maybe our country, where there is a lack of information about mediation. We have made a research, and only 33% of Czech population knows what mediation is. So, for example, in my point of view, we should inform potential parties of disputes. On the second place, maybe make some motivations, especially positive motivations. For example, mediation free of charge, etc. And maybe the coercion to force parties to mediate is the ultima ratio, the last step. So I don't know if this was the topic you have discussed, or it was something else.
I understand. I understand your point of view. Yeah.
Yeah, thank you.
Thank you. Thank you very much.
Okay, and we have also a question for you, Jan.
I'm sorry, Alexander, where is the question?
At the chat, Frank Musabe, I have a request to the last presenter who said that you decided that mediation is not binding. What does this entail? And also there is a comment from some comment to a speaker, it should be okay to compel participation in mediation to start with, but there is no coercion to agree to a settlement. You are only completed to try. If mediation fails, you are still free to go to court.
Well, the question, maybe I can share the name of the case, but I not sure what Frank really want to.
Okay, I will try to give the voice to Frank, and maybe it will be easier to. Frank, now you can use the camera and the microphone, so maybe this will be easier to explain what you mean according to this question to Jan. I'm not sure if Frank heard that he has the opportunity of having speech now. So Frank, if you are still with us, you can just unmute your microphone and clarify your question to Jan. Do you have other questions to our speakers? Okay, 5 minutes left to our meeting, so if you don't mind, I will just, in a very short way, sum up this seminar, because today we heard about mediation from the perspective, finally, of 10 countries around the world, and the common conclusion is undoubtedly that mediation has the advantages of relieving the burden on the judiciary and increasing the efficiency of redressing claims. I hope that this experience is the first step toward our international cooperation, not only with University of Rwanda, but also with other universities. On behalf of Professor Gieruszyńska and myself, I invite you to cooperate and co-organize similar projects in the future. Thank you for bravely putting up with my emails, even as the blood flowed faster today morning in your veins when you received the news about the cancellation of today's meeting. Special thanks to Mary Rose. Sorry, Mary Rose, I won't try to spell your name. Mary Rose from the School of Law in Rwanda for her ongoing contact and co-organization and being always on time and being always with me with organizing this international seminar. Organizing an event in which we had to take into account 7 time zones was quite difficult, but we are glad that apart from today's temporary cancellation of the conference, there were no major surprises. And on behalf of all organizers, so University of Szczecin and Faculty of Law and Administration, University of Rwanda and School of Law, the Center for Forensic Practice is operating as a part of legal clinic at the University of Szczecin, and also UNESCO Chair for Social Sustainability. Thank you for today's papers, for today's speech, for attendance, for discussion. Recording of the seminar will be available on our YouTube of Legal Clinic, for sure on Facebook, and for sure I will contact you via email and send all informations. I also ask all speakers to send me your presentations, because some of them I have, some unfortunately not, because I would like to send these presentations to all participants. Thank you once again. Have a nice day. Have a nice night. Good night. And have a nice day. And I hope to say see you soon. Maybe during this next international seminar, which will be according to arbitration next time in autumn. Thank you so much.